Chapter 3. In this chapter, you will learn how to serve a copy of your completed forms and how to complete the Affidavit of Service form CSX 102 or CSD 101 to prove that the other party and the county attorney have been served. If you are using the district court packet of forms, you will not need to serve the county attorney. Anytime you serve another party with court documents, you must also file an Affidavit of Service. An Affidavit of Service is proof that the other party was served with copies of the paperwork. The form itself is not served on the other party. It's only filed with the court. Before completing the Affidavit of Service, it is important to understand what service means. Service is making sure the other party receives a copy of the forms you prepared for court. By receiving a copy of your motion forms, the other party knows when and where the hearing is. They will also know what you are asking the court for and your reasons for making the request. Service can be done in different ways. For a motion to stop COLA, you can serve the other party and county attorney by personal service, which means hand-delivering the forms to the other party at their home, or by leaving the forms with someone of suitable age or discretion who also lives in the home. Service can also be by mail, which means someone will mail the copies of the forms to the other party by first-class mail. Certified mail is not required or suggested for this type of motion. One very important rule to remember about service is that you cannot be the person to serve the forms. You must find a person who is not a party to the case and is at least 18 years of age to serve the paperwork for you. The person must also be willing to sign the Affidavit of Service in front of a notary or court administration. For a motion to stop COLA, you must serve the following documents: the Notice of Motion and Motion to Stop COLA, an affidavit in support of motion to stop COLA, and copies of tax returns or other proof of gross income for the past 3 years. Be sure to make 3 copies of all of these documents. 1 copy for you, 1 copy for the other party, and 1 copy for the county attorney. If you are using the district court forms, the county attorney will not need a copy of your forms. Not only is it important for you to properly serve your forms, you must also serve them on time. There are different service deadlines depending on the type of service you plan to use. If you plan to serve by personal service, the forms must be hand-delivered at least 14 days before the hearing date. If you plan to serve by first-class mail, they must be mailed at least 17 days before the hearing date. If you do not serve your forms to the other party on time, your case may not be heard or your motion may be dismissed. This could result in the COLA increase going into effect. So, the sooner you can complete these forms and serve them to the other party, the better. Important: if your case is in the expedited process, then you must serve and file your forms no later than April 30th. If you miss the April 30th deadline, the COLA increase will happen on May 1st. Remember, you cannot serve the forms yourself. You must have someone over the age of 18 serve the forms for you. As we discussed earlier, this can be done by personal service or by first-class mail. After the parties are served, whoever served the forms for you must fill out and sign in front of a notary the Affidavit of Service form CSX 102 or CSD 101. This form cannot and should not be signed until after the service is complete. A copy of this form does not get served on the other parties. It is only filed with the court for your proof of service. You may need more than 1 Affidavit of Service form if you plan to serve both parties by the same type of service. For example, if you plan to serve both parties by mail, then you will need 2 Affidavit of Service forms, 1 for each because there is not space on the form for both parties' addresses. There are times when you may not know the other party's address and have been unsuccessful in finding it. If you have tried to locate the other party with no success, and the County Child Support Office is involved in your case, you may ask for a court order directing the Child Support Office to mail your papers to the other party. This requires additional forms to be completed. If the court orders the child support office to serve the other party, this would satisfy the service requirement. The Request for County to Serve Papers packet is available on the Minnesota Judicial Branch website. You can return to our website and click on the link to download and print those forms. Carefully read the instructions for how to fill out the request and affidavit for county to serve paper forms. When you are finished with the forms, file all of your forms with the court. Please be aware that even if you ask the county to serve the papers to the other party, you are still responsible to serve the county attorney with their copy of your motion paperwork, so you will still need an affidavit of service form for service on them. The Request for County to Serve Papers packet can only be used if your case is in the expedited process. If the county child support agency is not involved in your case, then you cannot use this set of forms. This is the Affidavit of Service form. Look for CSX 102 or CSD 101 on the bottom left corner of the page. You can fill out portions of this form yourself for the person who served your paperwork. However, the person who served the forms must be the person to actually sign the form. At this point, you already know how to fill in the caption of the form. Check the box for how your forms were served, personal service or service by mail. Remember, if you are serving both the other party and the county attorney by mail, you will need 2 forms. If you plan to use both types of service, then you can use 1 form. You will see an example of what the form would look like in that situation. Fill in the county where the affidavit will be signed. This may or may not be in the same county where your case is filed. In this example, the form will be signed in Blue Earth County. Betty Rubble is the person that served the forms for Fred on March 7, 2012. The forms that are required to be served are the motion to stop COLA and the affidavit in support of motion, along with financial documents. Betty served the plaintiff, Wilma Rubble, so she checked the box saying Wilma was served by mail, and Betty filled in Wilma's name and last known address. Betty will also fill in the city and state she was in when she mailed the forms to Wilma. In this example, Betty mailed the forms at a post office in Mankato, Minnesota. Betty's name, address, and telephone number are printed at the bottom of the form. Repeat this form for the county attorney if you mailed a copy to their office, being sure to check the box for the county attorney. The affidavit of service should not be signed until the person who served it for you is in front of a notary public or court administrator. The person must have a photo ID to have his or her signature notarized. If you plan to have the county attorney served by personal service, then you can use 1 affidavit of service form and check both boxes, and fill in information for both the other party and the county attorney's office. Be sure to write in the time the papers were served and the address of the county attorney's office. As I explained before, the person who serves the forms must sign the affidavit of service forms if more than one, in front of a notary or court administrator. This form does not get sent to the other party, only filed with the court. However, it is a good idea to make a copy for your records. This is the end of Chapter 3. Click on the next chapter for the finishing steps to complete your motion to stop COLA forms and file with the court.